I pray for listing of IA, my lord. Before we ready, my lord.
I for?
Consideration for suspension of the
Okay, when?
my lord, Friday, my lord.
Friday may be difficult. Have we done Monday next?
Okay. I beg to mention 7, 8, 9. May this matter will be adjourned for today, Lord. That's it.
7, 8, and 9 are connected.
Yes, sir. Yes.
Okay.
The statement is separate also there.
You're for whom?
I'm from JPI.
Amicus.
J-
When do you want? When do you want? When do you need?
I need
After
next.
2 weeks.
Okay.
Yes, madam. On a request made on behalf, and in the other matter, 7,
8 and 9.
AK Das is there. Who is
Yes.
AK Das?
AK Das, he was appointed as an amicus, my lord.
Okay. On a request made on behalf of the appellant. Comma. The matters are adjourned to be listed after 2 weeks.
Okay.
7, 8, and 9. Appellants को बाहर appellant.
Fine.
Attack into the state road. It will be debt reference. So what is?
Please, your lord. I recommend item number 5, my lord.
Yes.
Can be adjourned for a week, my lord. Engaging council out of station.
Item number 20.
5 and 6. 5 and 6.
Oh,
Analogous matter, my lord. I am for item number 5.
Okay, on a request made on behalf of the appellants. Matters are adjourned to be listed after a week. Yes.
Yes, my lord. Another item number 1, my lord. On behalf of NJ Das, amicus curiae, my lord. The matter may be adjourned, my lord.
Why?
He's out of station, my lord.
And then we'll appoint some other amicus curiae. 19 matter. Why should we wait for amicus curiae at his own convenience?
My lord.
What is the purpose of appointing an amicus curiae? That to a 19 matter.
My lord. That's not correct.
We're in 2024.
Any date next week, my lord. Any date. He'll be there, my lord.
No, the amicus curiae has a larger responsibility. It's
My
a
lord.
entrustment by the court.
Right.
And had it been a new matter, matter would be different. From 19 we are in 2024. 5 years it's pending in the High Court. Will it look good?
Or can be on Friday, my lord.
A request has been made on behalf of Sri NJ Das, amicus curiae, appearing on behalf of the appellant for adjournment. Full stop. Considering that the appeal is of the year 2019, a final opportunity is granted, directing listing of this matter on Monday next.
Obvious.
Okay. Date diva, huh?
May please, your lord. Which I am praying for listing of this criminal appeal, lordship, in the orders column. IA for bail is pending, lord.
Paper book has been prepared.
No, lordship, only LCR was called for, and it was for consideration of IA for bail, lord.
When was it admitted?
Not admitted, lord. Only
Appeal.
appeal. On 14/8/24.
14/8. Okay, we'll have it. When?
Next week, lordship, 128.
May I please, your lord? I beg to mention item number 2, lord.
Yes.
Between 3, lord. I pray for an adjournment, lord.
Again, 19 matter. Why are you seeking adjournment?
After there is some personal difficulty, lordship. Senior counsel, lord. Can it be after 2 weeks that it will
See,
be
it's causing prejudice to you and the system.
Lord.
19 matter.
19 minutes?
And we don't have much work to do. Yesterday we had to rise at 11 o'clock. That's not the purpose of having a special division bench for criminal matters. When?
After 2 weeks.
On a request made on behalf of Sri A.M. Bora, then a senior counsel for the appellant, list after 2 weeks, separate order.
20. Highly obliged.
In item number 2, why private respondent? TJ Mahanta is
Lord,
informed.
Lord, we had also submitted the adjournment schedule. Yesterday I informed them.
Okay,
Also for the item number 3 also we had informed them. I might
okay.
highly obliged.
2 weeks.
May it please your lordship. Lordship, I beg to mention for listing of an appeal, my lord, along with an IA, my lord, filed during
Fresh
the course of
matter.
vacation, fresh matter, lordship.
Whenever you say.
Lordship, can it be on Friday, my lord?
Tomorrow?
Lordship, maybe day after tomorrow, definitely, or
Day after tomorrow is what? Thursday?
Thursday or
Okay.
Friday.
Thursday.
Deeply obliged, my lord.
I'm praying for a listing for a IMI.
I for
I for checking for medical emergency.
seeking for?
Medical emergency.
What is the prayer? Prayer for bail.
Yes,
Just tell us that on the ground of medical emergency. When do you want?
next week.
When do you want? When do you want
Next
listing of the matter?
That next week.
Next week.
Next week. What is the medical emergency you are having?
He's suffering for a tumor.
Okay, Monday next. Appeal of which year?
2024.
Admitted when? Should know at least when was it admitted. Okay, Monday next.
May it please your lordship. My lord, in this case, my lord, there is no eyewitness, my lord. The my lord, conviction made only on the basis of some single circumstances that the sum of the witness, my lord, had seen the accused, the appellant, running from the place of occurrence, my lord. And then there is a contradiction between the my lord, witnesses, my lord. So, my lord, 10 circumstances was not established, my lord. There is no 10 circumstances, my lord. My lord, the incident took place in 2002. Kindly see the affair, my lord. Page 3.
Please read.
My lord. To the in charge officer, Khatkoti Police Outpost, Police Station Bokazan, District Karbi Anglong, Assam, is dated 21/7/2002. Sir, the humble submission is that around 9:30 p.m. last night, that is on 27/2002, while my elder brother Sri Gopal Chaudhary, as at 25 years, son of late Deben Chaudhary, was running from
Returning.
my lord, returning from riding a bicycle.
Returning home.
Sorry, my lord.
Returning home.
Sorry, my lord. Returning home, riding a bicycle after purchasing ration. Sri Shopon De, as at 38 years, son of unknown, killed him in front of the factory of Lahorijan Tea Estate near the railway track, and that when he was trying to bury the deceased in the marshy land, people caught him, Shopon red-handed. It may be mentioned here that since last 3 months, the deceased Gopal and accused Shopon had been working together. So it can be assumed that the incident took place because of monetary issues. Therefore, it is prayed that the necessary action may be taken in this regard and the accused be punished accordingly and obliged. This is my humble prayer before you. So my lord, informant is Krishna Chaudhary,
He is PW one.
My lord. And case was registered, my lord. Registered, my lord, next page, my lord. Received the FIR at Kotkoti OP by the GD number so and dated so and so forwarded to the OP, OC, so and so for favor of registered a case under section 302/2001 IPC. I have taken up the investigation, in charge officer. Then, my lord, page 5, my lord. In this case, my lord, total 8 prosecution witnesses were examined, including the, my lord, the medical officer and IO, my lord. And my lord, there was no witness from the, my lord, of accused side, my lord. My lord, kindly see the PW1, my lord, page 9, the informant.
Nine.
9, my lord. PW1, Krishna Chaudhary, the brother of the, my lord, the victim, my lord. In his statement, my lord, may I read, my lord?
Yes.
I know the accused person on the dog. His name is Shopan Kumar De. He is my co-villager. This is Gopal Chaudhary, is my elder brother. Gopal Chaudhary did business of Pan Tamul in the Lahorizan area. He used to carry his goods on a bicycle. On 20th July 2002, at about 10 a.m., my elder brother Gopal Chaudhary went out for his business. He generally used to return home by 8:30 p.m. On that day, I was at home. He did not return on the day till about 9 p.m. Suddenly, I heard halla, like Bachao, Bachao, and Mama, coming from outside from a distance of about 20 feet from my home. I told my mother that since elder brother has not yet come, let me go and see what this shout is. My mother also told me to see who is crying outside. Then I came outside to the point near railway line, Hanuman Mandir of Kotkoti. There I saw a cycle was lying. It was my brother. I also saw one bag of my brother lying there with some food items. Then I cried, Dada, Dada. On hearing, this is, my lord, important, on hearing, Gautam, Bhumik, Ashok, Phaguna came there. Thereafter, I saw Shopan Kumar De was running away toward Lahorizan tea estate side. People made halla, dhor, catch him and flogged him. Then the chokidar of the tea factory caught him. Thereafter, we searched my brother and found something in the nearby pond. We saw my brother lying in the pond. I could recognize him as Gopal Chaudhary. A t-shirt was wrapped on his neck. The body was pulled out of water. He was dead. I, along with Phaguna Rajbangshi, went to Kotkoti Thana and informed the police. The police came to the OP with us on the same night. Police made inquest over the dead body in my presence. Exhibit 1 is the inquest report. Exhibit 1:1 is my signature. Police searched the area and says one dhow, one hero cycle, one coffee color shirt in my presence. Thereafter, the dead body was brought to Thana. Police arrested the accused person who was kept there by people. Next day, I lodged the Izehar at Thana. Exhibit 3 is the Izehar. Exhibit 3:1 is my signature. Police inquired the matter and recorded my statement. The dead body was brought to Dipu Civil Hospital for PM examination. After PM, the dead body was brought to our home. Since the accused Shopan Kumar De was the only person on the spot with my brother, and he tried to run away after seeing us, I believe that Shopan Kumar De had killed my brother. So I lost Izehar at Thana in the cross, my lord. I do not remember the name of person who had written the Izehar, but it was as per my version. The accused lives near my house. The occurrence took place about 20 feet away from my house at about 9:30 p.m. It was dark. On the day of occurrence, I was at home. On hearing halla, I came out. It is not a fact that I have given false deposition in the court. The cycle that was found there and letter says by the police belonged to my brother. Police says one bag also. Page 10, my lord, PW2, Uttam Bhumik. May I read, my lord? I know the accused person on the dog. His name is Shopon Kumar Dev. He is my co-villager. He lives at Lahorizan. I also know the complainant Krishna Chaudhary. I also know his elder brother Gopal Chaudhary. He is no more. I came to know that he was killed by someone. Gopal Chaudhary did Pantamul business in the Lahorizan area. The occurrence took place about 7 years ago. The occurrence took place at night. On the day of occurrence, I was at home. I was sitting on the baranda after taking dinner. Suddenly, I heard halla mama from about 100 meters distance from my house. After some time of hearing the halla, I came out from home and reached the place from where the halla had come. This place is near railway line near a tea estate. Many people are already there. I also saw Krishna Chaudhary there. I saw one bag and one bicycle lying there. On reaching the place of occurrence, I saw the accused Shopon Kumar there, who was kept there by the public. I came to know that people were looking for Gopal Chaudhary. I, along with other people, searched for him. Then we found it in the pond nearby. His body was pulled from water by Krishna Chaudhary. It was the dead body of Gopal Chaudhary and a t-shirt was wrapped on his neck. Krishna Chaudhary informed the matter at Kotpati Thana. Police came to the OP on the same night and inquired the matter. Police says one Dow, one Hero Z half chain cover bicycle and one coffee colored t-shirt from the place of occurrence in my present OP. Exhibit 2 is the seizure list. Exhibit 2.1 is my signature. Did not go to signature. Did not go to Thana. The accused did not say anything in my presence. I did not know about any quarrel in between the accused and the victim. Rose. I went to OP. On the spot, I saw one bicycle lying on the PO. I do not see any of the said article in the court today. I only heard that Shopon Kumar De had killed Gopal Chaudhary. Then OP number 3, Zogai Tanti. Page 11.
PW4 is the agent. PW4. He saw actually. Eyewitness. Not the eyewitness exactly, but
May I read, my lord?
Yes, please.
I know the accused person on the dog. His name is Shopon Kumar Dev. He is from our Bosti, Lahorizan. I also know the complainant Krishna Chaudhary. He lives at Lahorizan. Gopal Chaudhary is the elder brother of the complainant Krishna Chaudhary. Gopal Chaudhary is no more. He was killed. The occurrence took place at about 8-9 years ago. On the day of occurrence, I was performing my duty at Lahorizan Tea Estate at night chokidar. Beside me, there were 2 other chokidars, namely Ajit Tanti and Ganesh. I am working there at chokidar since before the incident. On the day of occurrence, I was performing my duty with my colleagues near the factory of the tea estate. At that time, at about 9:10 p.m., we heard shout coming from near the railway line, passing near the factory of the tea estate. The spot was about 100 meters away. Then we ran toward the spot and saw accused Sopan Kumar Dev trying to run away through the mud and pitoni. He was running and coming toward us. We asked him to stop and told that we will not harm him. Then we caught him. He had hardly any cloth on his body, and his body was wet and muddy. Leeches were also seen on his body. Then I informed the matter to our manager. Manager told us to hand over the accused to the public and come back. And then we took the accused to the PO where other people had gathered and handed over to the public. The person whom we had caught is now on the dock. After handing over the man, I again come back to my duty. Next day morning, I heard that Sopan Kumar Dev was killed Gopal Chaudhary. The police called all the person to the Thana and inquired about the occurrence. Accordingly, I narrated the occurrence as stated above. Pros. There are water body between the factory and the railway line. The accused did not confess anything to us. Manager had asked us just to hand over the accused and return. So we did not go to the actual place of incident. We handed over to the accused to the people there and return. I did not see the place of occurrence in detail. I had seen body of Gopal Chaudhary lying there. I had not seen who had killed the Gopal Chaudhary. Page 12, PW4, Aguna Rajbangshi.
PW4, want to
PW4.
protect? Yes, who is
My
it?
page 12, Phaguna Rajbangshi.
Yes, who is he?
Phaguna Rajbangshi. Four.
Yes, yes, yes. Who is he? The driver,
No, my lord. Phaguna is a co-villager, my lord.
co-villager.
Co-villager. May I read, my lord?
Please read.
I know the accused person now on the dock. His name is Swapan Kumar Dev. He is my co-villager. He was a driver. I lighted all horizon. I know the complainant Krishna Chaudhary. He is also my co-villager. He lived near my house. He also know the deceased Gopal Chaudhary. He is the elder brother of Krishna Chaudhary. Gopal Chaudhary had 5 brothers. I know that Swapan Kumar Dev had killed Gopal Chaudhary. Gopal Chaudhary had a Pan Tamil shop. The incident took place about 8 years ago. I do not remember the exact date. The occurrence took place in the night at about 9:30, 10 p.m. to 10 p.m. At that time, I was at home. I was sitting in the courtyard in front of my house. Then I heard cry of someone calling Mama, and the shout was coming from outside toward that direction. I also met there Krishna Chaudhary, the brother of deceased Gopal Chaudhary, at a point near railway line near the tea estate. Many people came there. I saw a cycle lying there. There is some water body there. I heard some sound coming from the water. There I saw that accused Swapan Kumar Dev had pressed and kept Gopal Chaudhary inside water, thereby expressing him. Then I rushed there to catch Swapan Kumar Dev, but Swapan Kumar Dev ran away toward Lahorizan tea estate tea factory site through water. Police made halla, people made halla and followed him. Then the chokidars of the tea factory caught Swapan Kumar Dev and brought him to the PO. Body of Gopal Chaudhary was found dead in the pond. A T-shirt was found wrapped on his neck. I asked Swapan Kumar Dev about the matter. At first, Swapan Kumar Dev did not tell anything, but later he told Swapan Kumar Dev about the matter. At first, Swapan Kumar Dev did not tell anything, but later he told me that he had killed Gopal Chaudhary. Then I, along with Krishna Chaudhary, Lakhan Chaudhary, went to the Thana. Krishna Chaudhary filed an izhar at Thana. Police came to the PO with us. Police inquired into the matter. Then we handed over Swapan Kumar Dev, kept by the people, to the police. Police conducted inquest over the dead body in my presence and other people. Exhibit 1 is the inquest report, and Exhibit 1-2 is my signature as witness. Police seized 1 jungle cutting dao, 1 cycle, and 1 T-shirt from the PO, as shown by Lakhan Chaudhary, the brother of the deceased. Exhibit 2 is seizure list. Material Exhibit 1 is the jungle cutting dao and 1 T-shirt. Cycle was given on Jimma to the deceased person's brother. Thereafter, the police brought the dead body to the Thana. I also went to Thana along with Krishna Chaudhary, Lakhan Chaudhary, and other people. Thereafter, I returned to my house. I had seen that Swapan Kumar Dev had killed Gopal Chaudhary. I do not know for what purpose Swapan Kumar Dev killed Gopal Chaudhary. In prose, it is not a fact that I had not seen the occurrence. On hearing cry, I immediately come to the PO. At that time, it was 9:30 to 10 p.m. I do not know the reason of killing of Gopal Chaudhary by Swapan Kumar Dev. It is not a fact that I have given false deposition in the court. Aguna Rajbanshi come after the my lord Krishna Chaudhary.
Yes.
Page 13, PW5, P. Ganesh Thiru,
Yes.
the worker of the my lord tea factory my lord.
Hmm.
I know the accused on the dog. His name is Swapan Dev. He lived at Lahorizan. I also live at Lahorizan. At the time of occurrence, I was on duty at Kalghar. I also know the complainant Krishna Chaudhary. He lives at Lahorizan. I also know Gopal Chaudhary. He is no more. He had a pan shop. He was brother of Krishna Chaudhary. He was killed by Shopande. I also know Ojit Tati. He did work at Kalghar of the Bagan as night duty. The occurrence took place at about 8 years back in the night at about 10:30 p.m. At that time, I, along with Ojit and Jogai, were on Chokidar duty. At that time, I heard halla from railway line side. On hearing sound, I, along with Ojit, went toward the railway line. Then I saw a person came toward us with mud from Pitoni. Then I caught him with the help of Ojit, Jogai. I could recognize him as Chopin. Then our Bagan manager came out and told us to hand over the accused to the people. I came to know from the people that he murdered Gopal Chaudhary and fled away. I did not go to the murdered place. Thereafter, I returned to my duty.
Just a minute.
No, he's not so bad.
অজিত অজিত নাকি
No, no, Faguna.
ফটো পাবো না নাকি Many people came there, right? To Faguna, it pays 12 hours. Many people came there, believe it. Many people came there. Blind injury, sharp injury of it. It's a serological test question. Probably with a key but test question. Many people came there, believe it. I also met Krishna Chaudhary, brother of so at a point near railway line. Many people came there. Or that's my school is here. Residence to Dekwana. যদি 20 ফুট লাগে 20 ফুট মানে তো কোনো ডিস্টেন্স না হয় এইখানে 20 ফুট হবে এরকম মহামাস এরকম আছে স্কেচ এরকম সবসময় পেজ 52 নিয়ে অরিজিনাল কোনো ছিল ফিরে নাই কোনো একদম মানে খুব একদম পারফেক্টলি করেছে স্কেচ ম্যাপ হলো আপনার পেজ 52 at least সেটা গত করেছে এইটুকু বলে আর ওখানে মার্শাল ল্যান্ডগুলি এফএলএ ফ্যাক্টরি তো আছে ম্যানুফ্যাক্টরি আছে এই দেখেছি ওটা ভার্সন আছে সোকল আইসন যেটা মোটর ডুবাই ফেলে রাখিছে কিন্তু ইনজুরি নেচার অফ ইনজুরি তার একটু লগত মিলা নাই নেচার অফ ইনজুরি মই চালো হয় মাত্র এখন কি বলছে শেষ করে সেরোলজি টেস্ট আকবর বলুন কি হয়েছে ইয়েস প্লিজ প্রসিড
Thereafter, I returned to my duty. I do not know the purpose of murder. Police came and inquired me and I told before the police as told today in the court. In first, I know the accused person from 5 years before the occurrence. I do not know about any criminal case against him. The accused did not plead guilty. I caught him after about 5 minutes of the occurrence. I heard the matter from the people. Page 14.
I was sitting in the courtyard in front of my house. Then I heard cries of someone calling mama, and the shout was coming from outside from a distance of about 100 meters. Informant কয় যে ইনফরমেন্টের ঘরটা 20 মিটার 20 ফিট মেন রোড ইনফরমেন্টের ঘর দেন আপনি 100 মিটার 100 মিটার কম ডিস্টেন্স নহয় তাৰপিছত কি কৈছে আমি ফ্ৰম মাই হোম তাৰ ঘৰৰ পৰা এখন এই ভাগনাৰ ঘৰৰ পৰা then I came out and went towards that direction. I also met that Krishna Chaudhary. Krishna had already I visited. I had already he was there in the spot. আর ভারপুর তো 20 feet না আইতে ও মানে দেখি আগতে পাপাই দেখিছে 9:30 10টা বজা রাতে একে কই মানে ভাইকে তো ফার্স্ট পার্সন হলো মোৰ দাদা মা তুমি দেখিছে সেইবোৰ কোৱা নাই কোৱাই নাই কি কৰিব দিয়ে 100 মিটাৰ দূৰৰ পৰা সেই ভাৰপক লগ পাইছে তাৰপিছত দেখিছে ডুবাই মাৰি আছিলে তাত No, we say it is all. I also met the Krishna Chaudhary, the brother of the deceased Gopal Chaudhary, at a point near railway line, near the tea estate. Many people came there. সাধারণত 10টা বজে খুব পানি কেনেকে দেখিছে রাতে এই গাঁৱৰ মাজত না সেইটো ঠিক আছে বাৰু তাকে চাওঁ বেলেগ চাওঁ চাই লওঁ কোনোবা এটা corroborate কৰিছে নেকি yes please proceed
Page 14.
Hmm.
PW6, Sri Ojit Tanti. He's a Milot employee of the
another
team.
chowkidar
Milot, another chowkidar. I know the accused person on the dog. His name is Shoponde. He lived at Lahorizan near Pokazan. I also know the complainant Krishna Chaudhary. I also know Gopal Chaudhary. He is brother of Krishna Chaudhary. He is no more. I also know Ganesh Turi. He works at Lahorizan Bagan at Sokidar of Kalghar. The occurrence took place at about 8 years back. I do not remember the date, but it was night at about 9:30 p.m. At that time, I was on duty at Kalghar with Ganesh
don't
Turi.
say kalghar say kolghar what is
Kolghar.
kalghar Kolghar, factory.
Sorry, my lord, Kolghar. Kolghar with Ganesh Turi, Zogai Tati. I was guarding of the Kolghar. At that time, I heard Halla as chur chur and dhar dhar from the side of railway line. On hearing sound, I, along with Ganesh, went toward railway line. Then the accused came toward us with mud from Pitoni. I saw him. On seeing him, I caught him with the help of Ganesh Ojit. I could recognize the accused now on the dog. The
With the help
manager,
of, with the help of
with the help of Ganesh and
And?
Ojit.
Ajit, he is Ajit himself. Who is this other Ajit?
Ganesh and Ojit. Three, my lord, Chokidar.
What is his name?
Here, my lord, Ojit Tanti.
So there was two Ajit or what? There were two Ajits. No,
Maybe
there were
my-
not two Ajits. These are
Maybe-
points in your favor. Why don't you take it up? How many Chokidars are there?
Three Chokidar.
Names.
The names, my lord,
Jogai,
Jogai,
Ganesh,
Jogai,
and Ajit.
Ojit. Jogai, Ganesh and Ojit.
Thereafter, please read. I could recognize.
I could recognize the accused now on the dog.
Hmm.
The manager of the Bagan came out and told to hand over the accused to their persons. Accordingly, I handed over the accused. Thereafter, I came to know
From the
from
people.
people
Hmm.
that he murdered Gopal Chaudhary and fled away.
Okay. These are
I
things-
did not go to the spot of occurrence.
Hmm.
Thereafter, I returned and for what purpose he killed Gopal Chaudhary, I do not know. I do not know. Police came and inquired me, and I told before the police as told today in the court. In prose, I did not see the occurrence. The occurrence took place in the night. The accused did not confess anything to us. I had not seen who had killed the Gopal Chaudhary.
Okay.
Then, my lord, page 15.
Yes.
PW 7. Sri Ratul Thakur, health officer.
Hmm.
On 21/7/2004, I was attached at the Deepu Civil Hospital at Medical and Health Officer 1. On that day, I conducted a postmortem of the deceased Gopal Chaudhary in reference with Patkoti OPGD number so and so and found the following. External appearance. The dead body of a young average built male is lying in the postmortem hall. Rigor mortis present. Eyes and mouth closed. The left pinna of the ear is sharp cut at its periphery along with a whole length. The cut portion of the ear is lost. Diffused hematoma on the left temporal frontal area and mild black eye and sharp conjunctival hemorrhage. There was no mark of ligature around the neck.
Yes.
Cranium and spinal canal. There is difficult,
Diffused.
there is a diffused bruising of left temporal frontal area of scalp. There is undisplaced linear fracture of left temporal region. Membranes were hemorrhagic. There is extensive extradural hemorrhage on left side with displacement of the brain toward right. The cavernous sinus is turned. One of the space 16, one of the thorax was healthy. Pleury healthy, both the lungs and heart were healthy. Abdomen, all the inter-abdominal organs were found healthy. The urinary bladder was healthy and organs of generation were healthy. There was not other injury. Disease was or deformity, fracture or discollection. The injuries described are antemortem and caused by both sharp and blunt object. Opinion. In my view, the death was caused by compressing extradural hematoma, leading to cardiorespiratory failure. Exhibit 4 is the PM report. Exhibit 1 is my signature. Exhibit 4.2 is the signature of Joint Director of Health Services, Karbi Anglong, Tipru.
Yes, please.
Well, at page 17, the PW8, IO. On 20.
Just a minute. Injury আসলে কান কাটা হয়েছে more হয়েছে blunt as well as very sharp weapons. Previous community issue nine. Rather to issue another nine. That's what against the economy. So it is 49. Teaching after look your room. Four to both out. For a decade, almost here, decade at least I know that. ভাইকে একবার নতুন ভাইকে দেখাবলেও কোন কিন্তু পুলিশের বাইরে ভাই লইছে এনেছে বাকি আছে নাই আর আইওটো আছে Okay, please proceed.
Page 17, PW8, police officer. On 27, 2002, I was in the charge of Khatkoti outpost around 11:45 p.m. That night, one person, Krishna Chaudhary by name, came to the outpost and informed that his co-villager Swapan Dev had killed his elder brother Gopal Chaudhary. Receiving the news, I made the GD entry number so and so. Exhibit 5 is the GD entry and Exhibit 5.1 is my signature therein. At 12 a.m., I proceeded to the place of occurrence along with my staff and arrived there at 12:30 a.m. As it was night, I could not visit the place of occurrence properly and making arrangement of a guard to keep vigil on the dead body. I returned to the PS at 4:30 a.m. I again proceeded to the place of occurrence. I performed inquest over the dead body and examined the witnesses present in the place of occurrence. Thereafter, I prepared a sketch map of the place of occurrence. Exhibit 6 is the sketch map of the place of occurrence, and Exhibit 6.1 is my signature therein. I seized a dao used for cutting jungle that was used in committing the incident. An old bicycle and a coffee color t-shirt from the place of occurrence in presence of the witnesses. Exhibit 2 is the seizure list and Exhibit 1 is my signature therein. After this, around 8:30 a.m., complainant Krishna Chaudhary lodged an izahar at the outpost regarding this matter. Exhibit 3 is the izahar. On receipt of the izahar, I made Kotkoti outpost GD entry number so and sent the same to Bokazan police station for registering of a case. Bokazan PS registered case number so under section 302 IPC and entrusted me with the charge of investigation of the case. Exhibit 32 is my signature and Exhibit 33 is the signature of Sofiullah, the officer in charge of Bokazan PS, which I have recognized. After that, I performed the inquest on the dead body and sent the dead body to depot for postmortem examination. Finding sufficient evidence from the witnesses present in the place of occurrence against accused Sopon Dev, I arrested him and took him to Bokazan PS. Bokazan PS sent him to judicial custody. Thereafter, I collected the postmortem examination report. Finding sufficient evidence against Sopon Kumar Dev, I have submitted the charge sheet against the accused punishable under section 302/201 IPC. Exhibit 7 is the charge sheet and Exhibit 7.1 is my signature therein. In prose, the distance from the place of occurrence to the Kotkoti outpost is 3 kilometers. The occurrence took place in the railway track near the tea garden. As per the sketch map of the place of occurrence, the dead body was lying in the railway track and I found the dead body there itself. There was a night watchman in the tea estate near the place of occurrence. I have not mentioned in the case diary that I did see the assailant as to who had killed the deceased, and the watchman also did not witness the incident. He came out only after hearing the hue and cry of the public. The people moved around near the railway track. The accused hailed from the village near the place of occurrence. I do not know if the accused had any dispute with the deceased. During the investigation too, I did not come to know about any dispute. The witness said that the accused had killed the deceased. It is not a fact that the witness did not say that the accused person had killed the deceased. It is not a fact that I have adduced false evidence in the court today. I did not make any proper in the case in the court to record the statement of the accused under section 164 CRPC. I did not send clothes of the accused to FSL.
Dow was sent for FSL.
I did not send clothes of the accused to
Dow.
Here we mention only
Was it sent for FSL?
no. My lord, in this case, my lord, 8 PWs are examined, 1 medical officer, 1 police officer, 3 co-villagers and 3 factory employees who are Tokidar, my lord. First, my lord, the informant, the petitioner mother came to the place of occurrence. He had seen that the accused ran away from the place of occurrence. Then other my lord came, PW2 and PW4, my lord. But PW4, my lord,
Yes.
PW2, my lord, sorry, PW10, page 10, PW2,
Hmm.
he said that the accused caught by the minor people, my lord. First he seen, come to the place, he met with the Krishna Sodari, the informant,
Yes.
and she saw that the my lord, the appellant was caught by the people. First Krishna Sodari, the informant came, he saw
Informant, PW1.
PW1, my lord,
Yes.
page 9.
Yes.
Because his house is 20 meters away from the my lord, place of
20
occurrence.
feet.
20 feet, my lord, away from the place of occurrence. He came, then he shouting, and on his hearing, my lord, the Gautam Bhumik, Ashok and Phaguna came there. So Gautam Bhumik, Ashok and Phaguna came after the PW1, my lord. PW1 seen that the accused was running.
The cycle of land, I told my brother also on some food items. Phaguna is
Phaguna Rajbangshi,
R4.
my lord. Phaguna is a population.
PW4.
PW4.
Ashok.
Ashok, my lord, here not examined.
Gautam.
Gautam, my lord, it is not examined. Uttam was examined. So Gautam may be some another person, or Uttam or Gautam may be same person. It is not mentioned, my lord. Uttam is PW2. But PW1 did not say about Uttam.
Just a minute, please. Gautam. Gautam. Already there. Please do something. Please get this thing. Number Gautam দিয়ে না হয় নিজে কোনো প্রিয় মিলিয়ে মা বলি পড়া তখন তারপরে আহিল many people were already there Mother Singh দেখুন কি হিসেবে বলতে many people were already there I also saw Krishna already there কিন্তু Krishna was the first person to read this night he found me with Nara he said I saw one bed and one cycle lying there Krishna লগত Mini civil research, second research was corporate policy. On reaching the place of occurrence, I saw actions performed towards step by the public. And in the meantime, Guliani public was from life. It had to be. I came to know that people were looking for Gopal. Gopal of Kwan This is the. I, along with other people, searched for him. Then we found it in the pond nearby. His body was pulled by Krishna Chaudhary. It was deputy for children t-shirt. আমি বেনিফিট অফ ডাউট দিছে বাৰু উত্তম আৰু গৌতম একে বুলি ভাবিলো বাৰু গৌতমক অনা নাই হেৰিক অনা নাই কি কয় সেইটোক কৃষ্ণই ই যে ভাইকে যে কৈছিলে দুজন মানুহ আৰু আছিলে এটা হ'ল ফাগুন আহিছে PW4 অশোক নাই গৌতম নাই কোনকেইটা ঘূৰিছে নহয় PW1 এইখিনি চব পাৰিব এক নম্বৰ মাজৰখিনি then I came out outside to the point near railway line Hanuman Mandir of Kotkoti. There I saw a cycle was lying. It was my brother's. I also saw one bag of my brother lying there with some food. I tried dada on hearing Takuni Palai. Gautam Ashok or Faguna came there. Thereafter we saw Sapon running away from the towards Lahorigan factory. People made halla dhod. Follow him. The chokida tried ধৰিলে এইখিনি মাজত যে ফাগুনাই যে নাৰেশ্যন দিলে ক'ৰ পৰা দিলে No, Krishna শুনি পেলাইহে ফাগুনা আহিছে কৃষ্ণ Many people came there. There was some water good. I heard some from them. Then I saw that I heard something. Yes.
My lord. First, Krishna Chaudhary came to the point and he shouting Dada Dada. Then, my lord, on hearing Gautam Bhumik, Ashok, Faguna came there. And he saw, Krishna informant saw, Sapon Kumar Dev was running away toward Lahorijan Tea Estate site.
Yes.
And then, my lord, kindly see the with PW2, Uttam Bhumik. But he had not mentioned the name of Uttam Bhumik in his, my lord, statement, my lord. But Uttam Bhumik was, my lord, examined as PW2. Uttam Bhumik said that many people were already there. I also saw Krishna Chaudhary there. So he got the Krishna Chaudhary. And I saw one bag. Then I saw the accused Sapon Kumar there, who was kept there by public. So public already got the Krishna appellant, my lord. Then, my lord, he found it is in the pond and his body was pulled out by the Krishna Chaudhary. Victim's body was pulled out by the Krishna Chaudhary. Then, my lord, kindly see the PW3. First, my lord, PW4, my lord. Then it will more clear.
4.
PW4, page 12. PW4, one of the co-villager, he said that, my lord, I met Krishna Chaudhary there. In the middle, my lord. So he also got the Krishna Chaudhary in the, my lord, spot, my lord. The brother of the deceased, Gopal Chaudhary. And then I heard the sound coming from the water. Then I saw accused Sapon Kumar Dev had praised. This is, my lord, most important. Because other two persons, my lord, who are also, my lord, first Krishna Chaudhary came, then, my lord, Uttam Bhumik, they did not say that, my lord. But my lord, the Phaguna Rajbongshi, he said that I saw the accused Swapan Kumar the head press and kept Gopal Chaudhary inside water, thereby expatiating him. But that statement was not made by the my lord, the first person, the Krishna Chaudhary, my lord. He said that the accused person running toward the my lord, toward the my lord factory site, running to the factory site, my lord. He first person said that you accused running to the my lord factory site. Then the next person who came later to the my lord, he said that the my lord, the appellant, my lord, praised the my lord and tried to put inside the my lord person in the my lord water, my lord. So my lord, there is a my lord contradiction, my lord. Then my lord, PW3, my lord. PW3, my lord, PW3, PW5 and 6, the my lord, the employee of the my lord factory, they said that the my lord, the accused person running toward the my lord, toward the my lord factory site, my lord, from the place of occurrence, my lord. But they did not visit the place of occurrence, and they did not know the my lord, exact place of occurrence, my lord. And they said that they came to know it is their my lord. They heard that the my lord Krishna Chaudhary was my lord, the victim was killed by the my lord appellant. So my lord, next my lord, there is a contradiction of medical report with the my lord, contradiction with the my lord PW4, my lord. PW4 said that press, the word used pressed and kept Gopal Chaudhary inside water, so thereby expatiating him. But medical report said that, my lord, PW7, my lord, PW7, page 16, page, my lord, first page 15, my lord. The external appearance, last sentence, my lord.
Yes.
There was no marks of ligature around the neck, my lord. Ligature means, my lord, like some tight or pressure, my lord. There's no such, my lord. But in but PW1, 2, and 3 said that the neck was raped with a my lord T-shirt, my lord. And the cause of death explained, my lord, in the opinion part, page 16. In my view, the death was caused by compressing extradural hematoma leading to cardiorespiratory failure. So, my lord, is a my lord, basic was compressing extradural hematoma. Extradural hematoma and extradural hematoma is a collection of blood in the potential space between the skull and the outer protective lining that covers the brain. It usually occurs because of a head injury. And the my lord, from the PW8, page 17.
Where do you get this literature? What is the meaning of
My lord,
compressing
I
extradural
get from the internet, online, my lord, but it mentioned in the order also. I'm going to see, my lord. Please read it. Order also, my lord. Then, my lord, kindly see the PW8. The intention or motive, there is no such intention of motive killing to the my lord, accused by the my lord appellant, my lord. In the cross part, my lord, my lord, he do not know if the accused had any dispute with the my lord deceased. During investigation too, I did not come to know about any dispute, my lord.
বন্ধ কৰি দিয়ক নি ঠাণ্ডা হৈ যাব পিছত অলপ পিছত বন্ধ কৰি দিয়ক পিছতলৈকে দিব Mr. Islam, yes, what?
My lord, then my lord, uh, so my lord, there was no intentional motive to kill by the, to the my lord, victim by the my lord, appellant, my lord. And from the position of my lord 4, he also said, I do not know the reason of killing of Gopal Chaudhary by Shopan Kumar Dev.
Who says?
My lord, PW4, Aguna Rajbanshi. And my lord, kindly see the my lord, page 36 of the judgment, my lord. Para 17, my lord. May I read, my lord? Evidence of PW4 showed that he saw the accused person placing and keeping the deceased inside the water of the pond. From the evidence of PW1, it appears that PW4 came to the place of occurrence after he had reached the place of occurrence. Even though evidence of PW4 itself shows that he came to the place of occurrence after PW1 had reached the place of occurrence. Evidence of PW4 is silent that he saw the accused person placing and keeping the deceased person inside the water. On contrary statement of PW4 recorded under section 161 of the CRPC, it is totally silent that he saw the accused person placing and keeping the deceased inside.
আৰু মিৰাজৰ ডাউটো হ'ল বুলি ক'লে তাৰপিছত কিহৰ ভিতৰত দিলে হ'ল কি ভিত্তিত দিলে suspicion এটা হ'ব কিন্তু এটা তুমি কথা বলে তো দৌৰি যোৱাটো is one of the factors but that's one of the sole factors and it is preceded by discussion that PW4 is not trustworthy এটা জেরার মধ্যে দেওয়া হয়েছে জেরা তো দিয়েও পেলে আপনি তো এখানে পুলিশের ওপর ফোন কিছু করে কিন্তু তেও নিজে চাইছে যে 161 কোন এখানে
my lord. On contrary statement of PW4 recorded under section 161 of the CRPC, it is totally silent that he saw the accused person pressing and keeping the deceased inside the water of the pond. Hence, I find there is a doubt that the PW4 saw the accused person pressing and keeping the deceased inside the water. Then, my lord, para 18, my lord.
PW4 গুলো বাকি আছে না? PW4 যদি যায়, বাকি এগুলো বিশেষ নেই।
Para 18, my lord, there is no dispute that one dhow having length of 1.5 foot, one old bicycle having half chain cover, and one coffee colored T-shirt were seized on 21/7/2022 in connection with treaty number so and so dated 21/7/2002 on being produced by Sri Lokhan Chaudhary in presence of Sri Uttam Bhumik. The presence, my lord, it is produced by Lokhan Chaudhary, the brother of the, my lord, deceased person, my lord. There is no evidence on record showing that says thou and sporting wear belong to the accused person. The exhibit 4 is the postmortem report which shows that death of the deceased was caused by compressing extradural hematoma leading to cardiorespiratory failure. So, my lord, paragraph 17 and 18, my lord, goes in favor of the, my lord, the appellant, my lord. And in fact, my lord, PW4, he also said that, my lord, the police says one Zongal Dao, one cycle and T-shirt from the place as shown by Lokhan Chaudhary, the brother of the deceased. As shown, my lord.
Who is Lokhan?
Lokhan, my lord, brother of the deceased. Here is
No,
mentioned.
not PW.
No, my lord. Lokhan was not examined, my lord. Lokhan was not examined, and here Phaguna Rajbangshi was examined, but from the statement of PW1, he also mentioned Phaguna. Phaguna may be some other title also, or maybe some other person. That is not mentioned. That this Phaguna and Phaguna Rajbangshi are same person.
That will be too hyper-technical. He
May-
said
my lord,
Phaguna,
my
but
lord.
Phaguna has
True,
come
my
as PW4.
That is true, my lord. But that is not mentioned, my lord.
Uttam and Gautam, these are different.
My
You may
lord.
be correct in contending that
My
Uttam
lord.
and Gautam. Yes, what is required in a matter of circumstantial evidence?
My lord, one judgment, my lord, I have.
Which one? Citation?
My lord, 2016 series Supreme Court 706.
2016.
2016 series Supreme 706. And My lord, Supreme today, I am collecting Supreme today. Para 10, my lord.
You do not know the SCC citation?
SCC citation, my lord,
Let me give 2016 12 SCC. 512. 251. Okay, name
para 10, my lord, of my lord copy, my lord. Of this copy, my lord,
Ram
Supreme today.
Braksh. Para
Para 10.
on what point?
My lord, last seen person, my lord. Para 10.
Here is the last seen together, the theory there, it's not there. Who saw that they were last seen together last?
Because my PW4 said that he praised.
No, last seen doesn't mean he is an eyewitness. He claims to be an eyewitness.
My lord,
It is not a last seen theory. Last seen theory that they are seen together, thereafter nobody knows what has happened. So that is the.
but conviction made only on the basis of some circumstances, not my lord.
There is no last seen theory here in this case.
Well.
If it was the case that yes, I saw the accused and the deceased going to from the house together and thereafter,
Well.
that is not the case. PW4 is something else. He said that I saw him
Well.
pressing beneath the water,
Well.
and that his evidence has been discarded,
My lord,
has been held to be not free from doubts.
my lord. But
Any other case on circumstantial evidence?
because of circumstantial evidence, the 5 points, my lord, that has not been made,
Which case?
my lord, I read this morning, my lord, there are.
Where is Birji Chand? Sarda,
Sada.
where?
Suraj Dev Mahto and another appellant, State of Bihar. My lord, Supreme today, 2021, 5 Supreme 297.
Copy.
Well, Para 27.
2211 SCC 800.
And it is mentioned in page, my lord, 8. Page 8.
Suraj Dev. Paragraph?
Paragraph 27. My lord, subparagraph 5, my lord. There must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused and must show that in all human probability the act must have been done by the accused. So, my lord, chain of the circumstances, my lord, was not, my lord, complete, my lord. And from the, my lord, depositions of the, my lord, witnesses, it is also, my lord, come to, my lord, it is also saying that, my lord, the other peoples also present there, my lord, because some other persons also there, my lord. And the, my lord, the company workers, my lord, the factory workers are not, my lord, seen the, my lord, directly. They also, my lord, heard, my lord. And they even did not visit the actual place of occurrence, my lord, at that time, my lord.
Yes, anything else
My lord, the para 19
of?
of the judgment will page 37.
Yes.
Learned, my lord, court also explain the, my lord, medical, my lord, terms, my lord.
You've seen that extradural
My lord.
hematoma. Yes,
May I read, my lord?
you have read this. You can read.
Anything, my lord, I'll give my reply, my lord.
Yes, Lord. I have seen this from PW 1, 2, 3, 4, 5, 6. All have categorically stated that after hearing the halla, they went to the place and they have seen that the accused who was running away, Lordship, he was in with a muddy mud in his body. And while he was fleeing away, then when they had shouted to heard, that the three Chokidar have got. And moreover, Lordship, regarding the injuries, in PM report, Lordship, there is a postmortem report, page number, Lordship, 47, Lord. Scalp vertebrae. There is a diffuse brushing of left tempora, frontal scap. There is undisplaced linear fracture of left temporal bone.
Yes.
And Lordship, on page 46 also, Lordship, wounds position and character. Number 2, page 46. PM report. The left pinna is sharp cutting at its periphery along its whole length. The cut portion lost. And the opinion goes with it. There was injury. For that, Lordship, in my view, the death was caused by compressing extradural hematoma leading to cardiac respiratory failure. And Lordship, all the PW, no enmity is there. To complete the chain of circumstances, they have no enmity. All have said that after hearing the halla, Lord, and there was only the accused person and nobody else. So the only the accused person. No other. If
No,
any,
other than seeing him running away from the place of occurrence, is there any other circumstance which will bind him?
at
Will it
one
be
moment,
enough for a
Lordship,
conviction?
no, so PW for he
And
have
what now, madam, what you have just now tried to urge, that there was an injury.
injury.
PW4 says something else. He did not see, he claims to be an eyewitness. He did not say that I saw him hitting with a dao. He said that I saw him pressing his head under the water, but that is not the cause of the death.
Lordship, before that, Lordship, all have came there on hearing that Ma,
Yes.
Allah. Maybe he was
No,
earlier.
maybe, see, the
that
moment,
maybe is not there.
moment you say maybe, then
Maybe
we
it's
are,
not.
see, these,
I'm
we are,
sorry.
we are, we are,
I'm sorry.
we are,
No, no, no.
we are examining a criminal case
I'm sorry.
where the degree of proof is
Lord-
beyond all reasonable doubt. There is no other way.
Lordship, hearing the halal in the PW1, Lordship. Uh,
So what, madam, we can cut down this very short.
Lordship,
See, PW4 has been discarded.
Lord.
Because PW4 says when I had reached the place of occurrence,
Lord.
PW1 was already there.
Lord.
PW4 in his 161 did not say that I saw the accused pressing his head.
Lord.
So those were within the domain of the trial judge. He's had a comparison. There is no cross-examination. It's a different matter, but
There-
he took the pain. He looked into 161 and found that there was discrepancy. He did not say it before the police. But, and therefore he has discarded. So only evidence remains is that he was found running away from the place of occurrence. Will it be enough?
And defense also did not try to prove that. this
No,
factor-
defense is
And
not required to
Lordship,
prove
in
anything.
313,
It's a criminal case.
Lordship in
313 is said all false.
that is Lordship, that
All false.
even he, that is making of Thursday also he have said it's false.
Okay, he has,
He have no explanation.
it's
he has
not
neither
required, not required in a criminal case. Why should he explain?
All
I say
the-
I'm not guilty, that's enough. The burden is entirely on the prosecution. The dao was not put to forensic test. If the death was actually because of some injuries on the scalp and the brain, there was no connection of the dao and the accused.
Lordship, in question number 18, Lordship,
Yes.
do you have anything to say? No, I have been falsely implicated. I did
implicated.
not go through the wetland as said,
Yes.
but he was through the wetland. All the witnesses are there.
See,
And no
as a
witnesses
defense,
are
he is
anything.
entitled to take any defense.
But he have neither stated that, no, I was not there, but while.
Madam, do not confuse with a criminal case and a civil case. He is not required to make a statement.
And
Once he says, I am not guilty, I am innocent, that's enough.
but in 106 also the
What is 106? 106, what circumstances one is required to explain? Will 106 be applicable? Now, what we are slightly worried is that discussion on PW4 is paragraph 17. Though you are not required to go by the judgment, learned Session Judge says that PW4 is not trustworthy.
Right.
The conviction is only on the discussion at page 20, paragraph 20, page 38. Because he was found running away.
Lordship, when he was alone, Lordship, no other person. Only alone.
There were many other persons.
No, Lordship. Only the accused was running. Lordship.
That
Other way not running.
will that be a circumstance enough to convict him of a charge of 302? That he was found running away. One may be scared. There may be 100 other circumstances.
Lordship,
This
he
is
was
conviction.
only the person with the.
This will raise some doubt
That-
that he may be involved, but that doubt has to be corroborated with other evidence. We are not saying that his running away will make him scot-free, but what are the other evidence to connect him? What about the dao? Where about his fingerprints? Connect the dao with the injuries. No serological test. Even the T-shirt was not sent for FSL. And have you seen the sketch map, madam? Even the place of the residence, which is stated to be 20 feet. 20 feet is nothing. Maybe from, this is 10 feet. Maybe the end of the room is 20 feet. It's nothing. And one says he's 100 meters. 100 meters is quite a distance. From 100 meters, is it possible to hear mama? 100 meters is not a nearby distance. 20 feet. So at least in the sketch map, his house should have been shown. See the sketch map at place
Lordship.
52. Page 52. Have you got
Lordship,
52?
lordship,
Left, there's a factory where
lordship.
3 chowkidars are
Railway
there. And between the factory and the railway line, there is marshy land.
Marshal.
So there is no question of there
Paddy
being
field.
any house. Then the railway line. Then the village is on the right side. His place of occurrence is on the other side of the railway line. Place of occurrence, PO. Then their house has to be somewhere on the right side. It is not even shown. It said paddy fields. Investigate, what kind of investigation is this? At least indicate the distance. How much would be the distance nearby, around about? Nothing has been shown.
The injuries goes with the PM.
আৰু এইখিনিৰ পৰা এইখিনিতো ঘৰ হ'ব নোৱাৰে মাৰ্চিলেণ্ড ঘৰটো এইটো চাইডে হ'ব লাগিব এইখিনিত পেডি ফিল্ড বুলি কৈছে 20 ফিটৰ মানে ডিষ্টেঞ্চে নাই এই ৱালখনতলৈকে 20 ফিটৰ বেছি হ'ব এইখিনি 25 ফিট মান হ'ব তাতে ঘটনা এটা হৈছে ঘৰৰ মই গম নাপাওঁ আৰু শুনিছে মামাকে মোবাইলটো হয় কিন্তু কানেক্ট কৰিলে নহ'ব নহয় একদম হেৰি হ'ব লাগিব সেইখিনিৰ এনাফ নহ'ব না কনভিক্ট কৰিবৰ কাৰণে See, the only saving grace was the evidence of PW4. And PW4 from the discussion at paragraph 17,
Yep.
we find that PW4 is not trustworthy. PW doesn't even say he's the one brother that I saw this was happening. And he was the first one to reach the within 20 feet. And PW4 reaches, he stays around 100 meters.
100 feet.
Lordship. Injuries are there, lordship, that medical report injury is there.
An injury is on the scalp. That is why there was clotting of blood, he passed cardiac failure.
Lord. That is there in the
And
PM.
ligature is not there on the neck.
He was
Ligature mark was not there.
no, Lord, as he was, the opinion is not.
And
for
one of the
ligature.
circumstances could have been that there was previous animosity. It is not there.
It is not.
In fact, the evidence is on the other, on the contrary,
But
that
there
nobody has said that there was any.
enmity or any. And even the witnesses also have no enmity. Some benefit they pick after. also.
They are not having business together. He is a driver. One is having business of betel nut.
Not-
He driver বুলি কৈছে না কোনোবাই what কৈছে দেখিছে মই driver বুলি কৈছে And it was 9:30 in the evening, late,
Right, right.
and that too in the village. How could PW4 has been rightly discarded? How could he see or claim to have seen? When PW1 was, his own brother was there, he did not see say anything. In 161 also, PW4 did not say anything.
No. Only is that the Chokidar, after hearing him, caught him, he was.
Chowkidar has caught him running, fleeing away.
fleeing away.
Chowkidar, that version will not be enough to convict him. Anything else, madam?
So all the witnesses are lordship, after hearing Halla, they appear the place of occurrence and all are,
See-
all are
See,
categorically saying.
PW4 is not trustworthy. So what remains
Then lordship.
is only
PW
circumstantial evidence.
lordship, then
So
PW.
are you able to establish a link, a chain of events unbroken at any point of time to lead to a conclusion that it is only the accused and nobody else who has committed the offense? That is the test.
As the dead body was found in a pond lot, and he was also in a mud in his body. Or that then lordship
Will it be the
PW.
only conclusion that it is him, only him and nobody else who could have committed the offense?
There was no one lordship except him in that position lordship. Only he, only the accused was. All the three chokidars who are not at all related or thing to the accused, but
Even he was not
Currently,
related.
this is lordship.
He was
Because-
not related. He was
That
not
is lordship.
connected.
because the
No business rivalry, nothing, no same profession. They were different.
and he was running towards the spot, saw the accused upon trying to run away, throw the mud and returned. And the dead
See,
body
madam,
is
what
also
has
found.
actually happened and what is required to be proved in the court are different matters. Something like what actually happened, we do not know. But what did the prosecution discharge their burden in the manner which is prescribed in law, required in law? Any case law you'd like to rely upon or anything else, madam?
Lordship. Also in 106 lordship, when the accused is resting on circumstantial evidence, if the accused fails to offer a reasonable explanation in discharging the burden of placed on him by virtue of section 106 of the Evidence Act, such a failure may prove an additional link to the chain of suffering. And in this case, lordship, he is not able to prove any explanation.
One 106 will come into place when you make out a case for that he is connected. First, you have to make out, discharge that burden. Except he is running away, that too, he was caught by the chowkidar, not in the place of occurrence. At the factory, near the factory. What is the case law you are trying to refer?
Ah,
No, you have just,
or lordship, that is lordship from Balveer Singh lordship.
citation,
2003 SCC on 1261
2000,
2023
2023,
1261 SC 1261
yeah,
lordship
1261.
lordship page number
Balbir Singh,
lordship para 36 lordship.
what has been said? What has been said?
Lordship, thus the section 106 of Evidence Act will apply to those cases where the prosecution has succeeded in establishing the fact from which a reasonable inference can be drawn regarding the existence of certain other facts, which are within a special knowledge of the second paragraph is that is it of the knowledge of the accused. When the accused fails to offer proper explanation about the existence of the said other facts, the court can always draw an appropriate inference. when a case is resting on circumstantial evidence, if the accused fails to offer a reasonable explanation in discharge of burden placed on him by virtue of Section 106 of Evidence Act, such a failure may provide an additional link to the state of circumstance in case governed by circumstantial evidence. If the chain of the circumstance which is required to be established by the prosecution is not established, failure of the accused to discharge the burden under Section 106 of Evidence Act is not relevant at all. When the chain is not completed, falsity of defense, no ground to convict the
Convict. You see? 106 will come only when you are successful in establishing an unbroken chain. Then he has to explain. Now first, the burden is on the prosecution. Okay, anything else? That's all? Everybody. I'm Islam, A. Begum. Hearing is concluded, judgment reserved.
Ali obliged you.
From criminal to matrimonial.
Matrimonial appeal?
Yes.
Okay.
My lord, by the wife, my lord, the divorce decree has been passed.
Other side? Who? Okay. Appellant wife, second party.
Wife. He is now outside from the house now.
Now, decree of divorce has been passed. Parties are Hindus
My
under
lord,
the Hindu Marriage Act.
Pardon?
Under the Hindu Marriage Act or Special Marriage Act?
Yes.
Hindu Marriage Act.
Hindu marriage.
Okay.
Hindu marriage.
Okay. 13 petition. Oh, which court?
My lord, this is family court, Nalbari. Having one daughter.
Okay. Yes, please. Marriage
Yes. Married in 2013, ma'am.
2013.
25 2013. 20th May.
20th of May.
Ma'am.
Marriage. Okay.
Sir, this is the judgment first, madam.
You can just, yes, you can. This is the
Because
judgment.
fact will come, my lord. But page 10, madam.
Yes.
Second para, my lord.
Hmm.
The petitioner's case in brief is that following his marriage with the respondent as per Hindu marriage right custom on 20th May 2013, both of them started living as husband and wife at the petitioner's house at Dhantala, Nalwai. After marriage, the respondent insisted on shifting from ancestral land where the petitioner lived with his elder brother Raghav Nath and his family. In this connection, there has been frequent discussions between the respondent and the petitioner. Petitioner had refused to leave the ancestral house. The petitioner was alarmed when the respondent had threatened to commit suicide. On 24/12/2014, in the morning, the respondent had asked her brother and uncle to come to the petitioner's house over phone. Having arrived at the petitioner's house, the respondent's brother and her uncle had collectively assaulted the petitioner and damaged the TV and the glass top table. When the elder brother of the petitioner and his wife tried to intervene, they had misbehaved with him. The respondent accompanied her brother and an uncle back home. Thereafter, the respondent had lodged the FIR at Nalbari PS alleging cruelty against the petitioner, and then on the order of the court, a complaint case being number 22, understand 403, he collected the street on for the house of the petitioner. Then respondent in 125 proceeding had been awarded with 4,000 for her minor daughter, had been allowed 2,000 in maintenance amount. In revision, referred upon reduced to 5,500 by the session judge Nalbari. Since the respondent has been living separately from him since 24/12/2014 without his consent, not willing to cohabit with him, the petitioner had decided to seek dissolution of their marriage through the decree of divorce on the ground of disjustice. Respondent Deepika Saloi, in response to a summons received, put in her appearance for the court and filed a case. The answering respondent attributed her differences with the petitioner to illicit relationship of the petitioner with his sister-in-law Dhanada Nath that came to light immediately 2 months after the marriage of the petitioner. When the respondent confronted the petitioner in this regard, he used to become violent and at times assaulted her. After the daughter was born to the petitioner, they demanded rupees 3 lakhs in case. On her refusal, the petitioner on 24/12/2014, armed with his stick, had struck several blows on her after having confined her inside a room. The following morning, she had been driven out along with her daughter. On her way back home with her daughter, she had lodged an FIR in Nalbari PS alleging cruelty against the petitioner. The answering respondent also claimed receiving 5,500 following an order of 125 in the proceeding. The answering respondent claims being willing to resume conjugal life with the petitioner. Still, my lord, thus, in the circumstances, answering respondent prays for dismissal of the present petition. Following issues has been framed upon the pleading to decide the case. After solemnization of marriage, whether the respondent has discharged the petitioner for a continuous period of not less 2 years, immediately preceding the presentation of petitioner, whether petitioner entered into a decree of divorce, sought relief. Issue number 1. After solemnization of marriage, in his evidence, Vipul Nath attributed a cause for filing the present petition for divorce of the respondent living separately since 24/12/14, and the alleged fact that the respondent having collected all her estate from house of the on the order of the court. PWN also contended that on 24/12/2014, the brother and uncle of the respondent had come to the house and having assaulted him and also damaged the TV and valuable articles. PWN further contended that the respondent having initiated criminal proceeding against alleging cruelty and demand of rupees 3 lakh in case against him, his brother Raghav Nath and his wife Dhanada Nath and Dipankar Nath. According to PWN, he has been paying 6,500 in maintenance allowance to the respondent and her daughter following the order in 125 CRP and then in 127 the proceeding for enhancement. The PWN produced a certified copy of the FIR in connection with the GR case number 22 by the respondent. Exhibit 1 is the state FIR. Exhibit 2 is a certified copy of the FIR lodged in connection with the GR case number 22 by his brother Raghunath. In his cross-examination, PWN admitted not having gone to the house of the respondent to bring her back. my lord, once my lord changed outside, he never went my lord to bring her back. PD1 deposed to living in the same compound, which is brother Raghavnath at the paternal house. PD1 denied suggestion that he had illicit affairs with the wife of the Raghavnath, and the respondent had known about it. PD1 contended that in the criminal case filed by the respondent against him, the respondent has also alleged about the illicit relationship in the affair lodged. PD1 denied the suggestion that he had been caught assaulting the respondent by her family members who had rescued her. PD1 admitted not having gone to the house of the respondent's parents, bring his wife and the daughter back. PD1 admitted to the criminal case registered on the affair by his brother Raghunath, pending in the court for trial. PD1 Raghunath, the brother of the respondent, corroborated PD1 about the alleged assault by the brothers and uncle of the respondent number 1 and damaging the TV at PD2 house on 24/12/2014. PD1 admitted lodging the FIR against the brothers and uncle of the respondent with Nalbari PS, case number so-and-so, under so-and-so. FIR lodged by respondent Nalbari PS against the brothers, petitioner Raghavnath and Dipankar Nath alleging cruelty and demand up to for 3 lakh in case. PD2 corroborated PD1 on all facts alleged from the respondent collecting all her steed on the order of the court to receiving maintenance allowance to the tune of 6,500 from PD1 on order of the court in 125 CR proceeding. PD2 also claimed about the respondent staying away from the PD1 since 24/12/2014. In his cross examination, PD2 admitted being aware that the respondent lodging affair allegedly creating cruelty and demand for dowry against Vipul. He also admitted having lodged affair against assault upon Vipul and her sister-in-law Dhanada by the brothers of the respondent and for damaging valuables. PD2 denied the suggestion that he framed the brothers of the respondent in a false case. PD2 Nomalnath, one of the neighbors of the prisoner, stated that the respondent insisted of living separately with the prisoner. The prisoner's refusal to shift to another place from his ancestral house resulted in serious differences between the petitioner and the respondent, with the respondent threatening to kill herself, for which PD1 had to be on constant watch. PD claimed being aware about the brothers and uncle of the respondent coming to the house of the petitioner and assaulting him, damaging TV and valuables, and also misbehaved with the sister-in-law Dhanada. Now, PD admitted being aware about the criminal proceeding brought by the parties against each other, and in this regard, PD also stated being aware about the respondent living separately from the petitioner since 24/12/2014. In his cross-examination, PD admitted being aware about the villagers living all the ties with the family of Vipul Nath and his brother. He denied the suggestion that the alleged incident on 23/12/2014 had emanated from the alleged illicit relationship between Vipul and his sister-in-law, Dhanada. PD from Pankaj, a common friend of both the petitioner and the respondent, attributed the cause for differences between the petitioner and the respondent, not willing to live at the ancestral house of the petitioner, where the petitioner and her elder brother, Raghav Nath, lived. PD also claimed being aware about the respondent threatening to commit suicide on 23/12/2014, following her quarrel with the petitioner in the night. He also claimed being aware about the brothers and uncles of the respondent assaulting the PW1 on 24/12/2014. Both respondent and Raghu and brother of the respondent PW1 had lodged FIR at Nalbari PS against each other following the incident of 24/12/2014. PW also claimed being aware about the respondent living separately from the prisoner since 24/12/2014. In cross-examination, P24 admitted to being immediate neighbor of the prisoner. P24 also stated being aware of the Raghav Nath, the elder brother of the prisoner, working to the railway and living separately at his place of service. After marriage, Vipul Nath lived with Raghav Nath family. Raghav Nath's family stayed in the same compound. P24 denied suggestion that the prisoner had to maintain illicit relation with his sister-in-law. P24 admitted to the alleged fact of the petitioner not visiting the respondent since the day they have been living separately from each other. DW1, Deepika Nath Haloi claimed having got married to the petitioner on 25 and 13 and living with him as husband and wife at his house. DW1 claimed having divorced, discovered that the petitioner illicit relationship with his sister-in-law, Dhanaranath. According to DW1, whenever she had confronted the petitioner in this connection, the petitioner and his sister-in-law used to subject to her both mental and physical torture. Following the birth of a daughter, the petitioner demanded to be still in case. On 24/12/2014, the petitioner armed with stick had administered several blows on her and then had driven her out of her house. Nolbari PS case number so under 498A has been registered against the petitioner on her FIR lodged following the incident. In relation to the elder brother of the petitioner has lodged the FIR bringing false allegations, and in the trial, accused persons have been acquitted. DW1 admitted to have receiving rupees 5,500 in maintenance allowance from the petitioner DW1. Contended since he had been driven out by the petitioner from his house, he had no ground of seeking divorce on the ground of desertion. Exhibit 1 the FIR in Nalbari PS case number 22 lodged by her. In cross-examination, DW1 failed to bring the light the date and place when he discovered the petitioner illicit relationship with his sister-in-law. DW1 failed to specify the date on which the petitioner demanded to be luck from her and also her injuries sustained allegedly assault the petitioner. DW1 denied the suggestion that he had insisted on shifting the different accommodation to the petitioner from his ancestral house. He denied the suggestion that on 24/12 his brothers and uncles had assaulted the petitioner and damaged the TV and glass table. DW1 admitted to have collected all articles brought in her marriage from the house of the petitioner on an order of the court in a complaint case number so. Claimed to have got quarrel. DW1 claimed to have got quarrel twice and once demand rupees 3 lakh. DW1 denied the suggestion that he intentionally brought coercion with the petitioner permanently to an end, and the alleged fact of petitioner demanding rupees 3 lakh is not true. TWR Sotindra Haloi, the brother of the respondent, claimed to have learned that the respondent about the alleged illicit relationship between the petitioner and his sister-in-law, and both subjecting the respondent to torture. Following the birth of the daughter of the petitioner, had demanded rupees 3 lakh from the respondent. According to DW2, on 24/12/2014, the petitioner had beaten her sister and with a stick in confinement of his house and had driven her out of the house. On being informed, DW2 and others had rescued her, and then an FIR has been lodged at Nalbari PS in this regard. Following the said FIR, another FIR was lodged by the elder brother of the petitioner at Nalbari PS on the false allegations against them. DW2 also related to his evidence about the respondent receiving 5,500 in maintenance allowance from them. In cross-examination, DW2 admitted to his sister living at her mother's house since 24/12/2014, also admitted to having lodged the FIR on that day by them. DW2 also admitted to the presence of Amulya Haloi, Jiten Haloi, Govinda Haloi, and Arvind Haloi at the police station. DW2 denied the suggestion that the above persons had accompanied him to the house of Vipul. DW2 claimed not being aware about the grounds for divorce. DW2 admitted about the petitioner's acquittal in the criminal case filed against him. DW2 also admitted about having received back all the articles given in the marriage to the respondent from the petitioner's house following an order of the court. DW2 also admitted the respondent receiving rupees 8,200 per month from the petitioner as maintenance allowance. DW2 denied the suggestion that his claim in regard to petitioner maintaining his illicit relationship is not true. On 13/1, we admitted the marriage after solemnization may be dissolved by decree of divorce on the ground the other party deserted the prisoner for a continuous period of not less than 2 years immediately preceding the present petition. Expression desertion means desertion of the petitioner by the other party to the marriage without reasonable cause.
Just a minute.
Page 16, last one, but one paragraph. Explanation. In this subsection, expression rejection means rejection of the prisoner by other party from marriage without reasonable cause. Now, this is the main. And without consent or against the wish of that party and includes willful neglect of the prisoner by the other party from marriage as grammatical variation and cognitive expression shall be constituted reporting. The alleged fact of respondent living separately from petitioner since 24/12/2014 following the marriage on 25/2013 and the alleged fact of present case having been registered on 9/1/17 has not been disputed by the. Thus, the statutory requirement of the parties requires to leave the party continuously for a period of 2 years before filing of a petition seeking divorce on the ground of desertion. It stands fulfilled. Hello, this is the main question, madam.
No, that is not the question. Read further.
Yes.
That is the factual part.
Factual part. The
There is other discussion.
petitioner has
whether-
now to discharge a pardon to
Yes.
substantiate that the respondent has been leaving the party on a petitioner without reasonable cause and without the consent and without the intention to bring permanently to an at the end cohabitation with the prisoner.
This
Factual
is what
circum-
we are interested in. See, factually, separation of 2 years is there, but we have to see whether the circumstances are such that
My lord.
even if one wants
Correct.
to come back, she
Yes.
has not been able to
My
come
lord.
back.
My lord.
Now, we have to see the,
Yes, yes.
please read this.
Factual circumstances brought on record by the witnesses of both the sides in the evidence indicate that there is a serious allegation brought against the petitioner by DW1, DW2, the respondent and her brother, respectively, in their evidence that the petitioner having illicit relationship with his sister-in-law, Dhanardana, wife of Raghavnath, the elder brother of the petitioner, with whom the petitioner lived at their ancestral house. The petitioner categorically denied the suggestion to put him in this regard in the cross allegation of DW1. It is for the respondent to substantiate the state allegation. The respondent DW1 in cross examination discussed about the admitted not being aware the date and place of the illicit relationship between the petitioner and the respondent. And for that matter, if he had all seen both of them in the act, the exhibit 1 affair has been mentioned the alleged fact of illicit affair. Since the allegation is a serious one, the evidence that required for substantiating the alleged fact has to be beyond approach and cogent. The oral testimony of the respondent as GTB1 in the court and mention of the exhibit 1 definitely not sufficient proof of this allegation. Though no issue has been framed on the cruelty as a ground for divorce, but such false allegation has been brought is not only a source of mental anguish suffered by the petitioner, but is an indication that the faith on the husband and wife relationship repose has been lost, indicating the relationship more conducive for peaceful living. It is also evident that evidence adduced by both the parties and respondent, there has been a criminal case registered and charged by Nalbari PS as on 24/12/2014, bringing allegation of cruelty and demand of Rs. 3 lakh in case in a FIR, and Pilu to Raghunath, the brother of the petitioner, bringing allegation of criminal trespass, criminal intimidation, mischief in the FIR, lodged against the respondent brother and uncle at the Nalbari PS. Certified copies of both these FIR has been exhibited by the petitioner in his evidence as PW1. DW2, the brother of the respondent in his cross-claims admitted that the petitioner has been acquitted in the state. Since the respondent has not been preferred an appeal against the judgment of the acquittal in the higher court, as DW1 having claimed in her cross-examination about the having squared over the demand of Rs. 3 lakh on 2 occasions, recognizing the evidence of preponderance of probability, the court is inclined to hold that preponderance is not in believing the evidence of DW1 with regard to the petitioner administering blows with a stick for not fetching Rs. 3 lakh and throwing her out. Due to admitting the presence of Amulya Haloi, Jiten Haloi, Kalindra Haloi, and Ravindra Haloi at the police station, along with him at the time of closing the FIR at Nalbari TS by the respondent on 24/12/2014, and their names finding place in the FIR lodged by Raghunath. In Exhibit 2, as the accused on the same day, Nalbari police station, the court is inclined to hold that the preponderance is in favor of the probability that the evidence of PW1 with regard to involvement of these persons being involved in the incident of arson and assault at the petitioner's house on 24/12/2014 is true, rendering the evidence of the respondent as a whole not being probable on the scale of preponderance of probability. Thus, I am not inclined to agree with the learned counsel for respondent that respondent has been driven out by the petitioner from his house. Decision of so and so cited by respondent does not factually and legally conform to the factual situation of the present case, and as such, the state decisions do not help the respondent in any manner. I am not inclined to agree with the submission of the learned counsel for the petitioner vis-a-vis the decision in Nilam so. The state decision granting of divorce has been contemplated, whereas complaint case pertaining to collection of children and application in 125 posting filed by respondent are pending for discussion. Thus, for the petitioner, the respondent living separately continuously for all these 5 years, having brought a cohabitation to a permanent and an attempt for reconciliation as envisaged in Section 9 of the Family Court Act. For a counselor, following the referral, having failed, no serious attempts has been made by either side to resume cohabitation. The indication that respondent had not only shifted from the house of the petitioner but from the state of things also. Further, receiving maintenance allowance in 125 proceedings, having collected all her children from house of the petitioner on an order of the order passed on her complaint against the indication that the desertion by the petitioner by the respondent of the petitioner does then substantiated. Issue number 1 is accordingly decided.
You have collected all your Sridhan also.
Sridhan, my lord, because I was in my house, my lord. But thing is, this my lord, here, he has been ousted, and the conduct of the husband, my lord, your ousted, he has one daughter. He never visited the house of the, my lord, the appellant. My lord, he has admitted it, all the admitted it.
No, those are different matters.
But
But,
that is the important matter, my lord.
Grounds of divorce on the divorce on the ground of desertion.
Well, desertion at what instance, my lord? Because I have been ousted from the house, my lord. Because I have found, my lord, that he has illicit
But
relation
your
to it.
allegations have been, he has been acquitted of those charges.
Well, that is another aspect, my lord. Acquittal, my lord, criminal case, my lord. It may be, my lord, that is.
That we understand.
My
but
lord,
That is one
but-
of the indications.
But the conduct of the, my lord, the husband, my lord, your office, one daughter, my lord, he has not even taken care of her daughter also,
So you have other
Hello.
remedies for that.
my lord.
will that be a ground for interfering with a decree of divorce? That he has not visited the daughter? Let
My
the
lord,
daughter file a
that
case
is-
against
that
the
is the
father.
It is a vital ground, my lord, that he has not visited
How
once,
is
my lord.
connected with a decree of divorce on the ground of desertion?
No,
That
desertion,
he
my
has
lord.
not visited the daughter.
My lord,
That will be a, that will
first
be an,
thing-
in-
first
that
thing,
will
my
be a
lord, your-
separate and independent cause of
Your
action.
loss is to see, again, my lord, see the evidence, my lord, that how, my lord, my lord, I have been, my lord, when that daughter was born, he demanded, my lord, Tirak. Well, that is the, my lord, normal fact.
Now,
my
that
lord.
is the allegation which you are making, and that allegation has been turned out to be not proved, and he has been acquitted. You
Hello.
did not prefer any appeal against that.
No, my lord, criminal case, my lord, that is, your loss is known, my lord, that there must be, my lord, proof, my lord. But here, my lord, he, on the preponderance, my lord, he has come to.
After all the serious allegation of having illicit relationship, are you in a position when you are saying that I am willing to come back?
Yes, I have said, my lord, that
You are
fact,
making serious allegation against your husband, and you say that you want to come back.
yes, my lord, even then, my lord, they are, in fact, is there, my lord, that is according to my lord. That I wanted to come back.
Mediation has failed, counselor has failed, 5 years the matter was pending.
My lord, that is not the ground, my lord, actually.
No, but simply by saying that I want to come back will not do. We are not finding any conduct of yours to show that yes, you are having a bona fide intention to come back. You are making serious allegations against your husband.
Well-
Thereafter, you coming back. And desertion, 2 years, as a matter of fact, it's there. Now only you have to see that whether it is out of force or out of compulsion or on your own volition.
My lord, that is to be seen, my lord,
Now
yes.
that has been discussed.
No, that is discussed, but my lord,
If it is by compulsion that you are in such a circumstance that you cannot come back, then desertion will not be there. But here circumstances shows that you, on the other hand, has given allegation turned out to be unproved, and you are still alleging that he is having illicit
Well-
relationship.
my lord, that fact itself, my lord, that because the husband, he will not take care of the daughter, my lord, for a single day, my lord. He will not
Again,
take
this is
information.
taking to a different cause of action.
My lord, no, not that, my lord, because for divorce, my lord,
Daughter not being taken care of, maintenance case, you file
no,
maintenance
maintenance case, my lord, maintenance, only.
How is it got to do with a divorce? The daughter has not been taken care of. There are remedies in law. We do not know, he may even seek custody of the daughter. Daughter is now a very minor.
My lord,
No? তোমার চাইছে প্রথমটাই চাইছে
my lord,
রেজিস্টার হয়েছে 17 ফাইল বরাবরই করেছে তেতিয়া
my lord, that statement, the husband, my lord, মই মোৰ পৰিবাৰত তেওঁ গুচি যোৱাৰ পাছত আনিব যোৱা নাই। পৰিবাৰ ও সন্তানৰ খবৰ ল'বলৈ পৰিয়ালৰ মা দেউতাক ঘৰত যোৱা নাই। Equally, my lord, the conduct, my lord, the father, my lord, my lord. This itself shows, my lord, that my allegation, my lord, that I have been ousted from the house is, my lord, because that is to be, my lord. Not that I voluntarily have come out from my. And when, my lord, female child is born, my lord, naturally, my lord, they become, my lord. So the demanded, my lord, the 3 lakh rupees.
See, there were allegations, rightly or wrongly, made by him that there was trespass, breaking of the television, assault, and thereafter he goes to the house to bring her back. He could have very well said that I had gone, she did not come back. He did not say that.
No, he may not, in fact,
See,
my lord,
making a statement is no big deal. Yes, I had gone, but she did not come back. He did not say that. In cross, he said, I have not gone there. Natural, after all these allegations. Okay, at 2 o'clock.
But there is one item, that item number 11, Lord. So it may take some time. Lord, may kindly fix day after tomorrow.
11 is criminal case.
Lord, criminal appeal, daily appeal.
This will not take time.
And Lord, has
Mr.
also single bench.
Sahabna,
Single bench is there.
only after have you read what
time
what has been written? Only
time
if
permits.
time permits.
Obliged.
If you have a difficulty, tell us frankly.
No, Lord.
Otherwise, don't make submissions like this. We'll accommodate, but not because we have a difficulty. We do
Got
not have any difficulty.
Can it be
Which item number?
11.
item?
To know
Or
it.
tomorrow?
Not tomorrow, day after tomorrow, day after tomorrow. Okay. Item number 11 on request.
I can place 2 or 3 judgments, my lord. My opinion is coming, my lord. There was only one extra copy still coming, my lord.
Okay, you can give the citations by the time.
My lord, 2004 7 STC 747.
2004.
7 STC 747.
Name?
My lord, name is Shyam Sundar Kohli versus Sushma Kohli. Time, sir.
Paragraph?
Paragraph 8 to 10, my lord. 8 to 10. 8, 10, and 12. Very short judgment. We have heard the parties and gone through the material on record with very clearly in view of the concurrent finding of it. Of course, so that the ground of failure is not. To find ourselves in agreement with the finding of the trial court as well as observation of the interim judgment, the appellant has not been able to prove the respondent has deserted the case. The evidence of record indicates that the respondent has been forced to leave the matrimonial home. We are in agreement of finding that the case to appellant. We had attempt to get her back cannot be. An attempt was made to rely upon the various documents in order to show that the respondent was holding herself out as wife to one Harisankar person. However, we find that the documents had not referred to nor relied upon the they had not been disclosed by the appellant. During the course of evidence on this behalf, no attempt was made to probe these documents. For the first time, when the respondent entered this box, she was confronted with these documents. She denied that she had taken out any life insurance policy. She explained how her name is there in the French. I'm saying, 12 months. On the ground of it will break down the marriage, the court must not lightly dissolve a marriage. The only the extreme circumstances that the court may use the ground dissolving marriage. In this case, respondent allows even before us has been ready to go back to the appellant. It's the appellant who has refused to take the respondent back. The appellant had made allegations against the respondent. He even went to the extent of filing a complaint of bigamy under Section 494 against the respondent. Thus, the complainant cannot came to dismiss. I stated above the evidence shows that the respondent is forced to leave the matrimonial home. It's the appellant who has been at fault. It can hardly lie the mouth of the party that who is at fault and who has not allowed the marriage to work to claim and the marriage to be resolved on the ground of offense. Guys, my lord, that is for short, my lord. 2010 4 SCC 476. Robi Kumar versus Jurmi Devi. paragraph 13 and 14. May that only that amendment to the act, the amendment Richardson has become a ground for the High Court. The question of Richardson High Court is that in order to prove a case based on the party alleging Richardson must not only prove that the other spouse was living separately, but also must prove that there is an animus discrepancy on the part of the wife, and the husband must prove that he has not conducted himself in a way which furnishes reasonable cause to the wife to stay away from the matrimonial home. Looking at the materials which has come on record in this case, it said wife has sufficient ground to live separately. In this case, the evidence of the daughter is very crucial. Well, here daughter's evidence is here. My full submission is this, my lord. Richardson is not on the free will of the wife, my lord. He was compelled to leave the house, my lord. After the daughter was born, my lord, when demanded to 3 lakhs, and thereafter she was beaten. And these facts are, my lord, stated by the wife, my lord, clearly, my lord. The lord will see the evidence of the wife, lord. Richard. And the conduct of the husband is also very important, my lord, that he has not visited the daughter even for a single day after he left.
Yes, Mr. Chaudhary.
Lord, here in this case, my lord, though cruelty is not an issue, but the desertion issue is conjoined with the cruelty itself on the basis of the evidences of reports. Your lordship has indicated about this also in respect of it. Regarding cruelty, my lord, the allegation, baseless allegation, unfounded allegation of illicit relationship with sister-in-law. But it's a cruelty, my lord. As per the judgment of the apex court also, it is nothing but a cruelty. And it
But you have structured your petition on 13(1)(b). That is for
13(1)(b).
desertion.
Desertion, my lord, there is a clear finding in the judgment itself, my lord. They-
No, if the allegations were made by you, grounds are yours, but
Yes.
you still have structured your petition under desertion. So we'll examine the desertion issue only.
Yes.
We'll not
Desertion
invent a
issue,
new
my lord,
or formulate a new ground. The grounds are statutory in
my
nature.
lord, ground, had I been at the respondent side, then I would have stated regarding this matter. That if I had been made party in her case, then I would have raised this point, my lord. Regarding illicit relationship that has been raised in the written statement itself. My lord, if in the written statement itself, my lord, it is raised, my lord. The apex court decision is very clear, my lord. Even if it is written in the written statement, it is reflected. It's a grounds for of cruelty, my lord. The ground has been substantiated by the respondent himself, my lord. Appellant himself, herself.
Herself.
That is why, my lord, that can learned family court judge also, my lord, discussed regarding this in respect of it. And according to his language, my lord, though no issue has been framed on cruelty as a ground of divorce, but then such false allegation brought is not
No, we have,
only a source
we have
of.
read those discussion. Discussions appears to be relevant, but you had the opportunity of
And
amending your petition
my
and include cruelty as the ground, but nonetheless, we have taken into account. You may be correct in contending that in
my-
written
my-
statement, first time
But,
the issue of having a extramarital affair was, and that
Yes.
that may amount to cruelty. That's a different matter. yes.
There are ample evidence about the records. And regarding desertion, my lord, desertion itself, my lord, on my part, my lord, I have done nothing regarding her ousting from the husband's house. There is nothing. She has released a lot of allegations against me regarding ousting her from my residence. But the evidences are very much clear that her brother and some persons came and made atrocities in my house. My lord, for that, police case was also lodged from both sides, my lord. And the case lodged against me, that was, my lord, I was acquitted. And these are the grounds, my lord, in the finding of the court, my lord, itself, it is reflected. And so desertion, my lord, that desertion, she, according to her own conduct, my lord, she has taken away her freedom from my house, and had her been any desire to stay in my house, she would not have done it, my lord. And her baseless allegations is the foundation of the case, that she has deserted herself from my house.
But Mr. Sayawala is harping on the issue that there has not been a single instance where you had made an attempt to bring her back.
My lord, where the allegation
And
of,
rather, in your evidence, you said that
My
I have
lord,
never been.
obviously, my lord, if there is cruelty, my lord, had I been there, my lord, to bring her, my lord, then the question will come regarding condoning her, my lord, cruelty. Here, how should I go to her place, my lord, to bring her back? Because she herself withdrawn from my society, my lord. And it is clear desertion on my part with the baseless allegation. And after lodging such type of allegations, whether she can come back to me, my lord. And regarding irretrievable breakdown, my lord, that has been created by herself. Though, my lord, there is no statutory provision regarding this, my lord, for getting a decree. But, my lord, in lots of cases, Supreme Court has been allowing
That is 142.
142, my lord. But I am not arguing on that point, my lord, regarding application of 142 here in this case, my lord.
We cannot.
My lord, I cannot also. But the situation she has created, my lord, with that allegation, in the judgment itself, it has been referred so many suggestions on the PWs, my lord, witnesses. That regarding illicit relations, my lord, so many suggestions have been put in each and every witnesses. who have denied, who denied this, my lord. So on her part, my lord, she alleged, but that could not be proved, my lord. And that is why, my lord, even section 23 of the Hindu Marriage Act is applied, my lord. In a reverse sense, my lord, it is the section 22 that has been referred, my lord, in respect of the petitioner for obtaining a ground for decree of divorce. But the spirit of the provisions, my lord, that a wrongdoer cannot, my lord, plead as a ground for decree, my lord. If it is reverse, my lord, that principle, my lord, that will be applicable to the respondent itself.
Which section are you trying to refer?
Section 20,
Yes,
decree in proceeding.
yes.
In any proceeding under this act, whether defended or not, if the court is satisfied that any of the grounds for granting relief exists,
Hmm.
and the petitioner, except in case where the relief is sought by him on the grounds specified in subclause A, subclause B, or subclause C of clause 2 of section 5, is not in any way taking advantage of his own, of his or her own wrong or disability for the purpose of such relief. Well, here I'm a petitioner, my lord. In this case, my lord, I have sought relief of decree regarding on the basis of the desertion, and my submission is that desertion that has been established by her own conduct, my lord, here in this case. So, my lord, for her own wrong, she cannot have the advantage.
No, she is not the
Hey.
first party. She is not seeking a decree of
She
divorce.
is not seeking, my
for-
lord, if
for
the
desertion.
principle is applied, my lord.
Had it been that she was staying out
Yes, ma'am.
separately on her own, then seeks a decree of divorce on the ground of desertion. This would have been applicable. But
Yes,
one more thing is this, while citing the case of Ravi Kumar, of the essential element of desertion, that is animas deserendi,
Yes.
has been discussed.
Yes.
And Mrs. Sahiwala says that even now, as on today, she is willing to come back to the matrimonial home.
my lord, I am citing another two things regarding cruelty and, my lord, on the basis of this case, my lord. I am referring, my lord, Air 2004, Delhi, page 39.
Name? Jai Dayal.
My lord, Joy Dayal versus Shakuntala Devi.
Paragraph?
Paragraph 10, my lord. 10 onward. This is on the basis of a Supreme Court judgment. In judgment reported as Vijay Kumar Ramchandra Bhate versus Neela Vijay Kumar Bhate, reported in 2006 STC page 334. It was held that leveling distinguishing
These
sorry,
allegations were leveled against the wife in this case.
yes, my lord. Here, my lord, vice versa, my lord. The wife has laws
But
allegation against.
these observations are made in the context of a lady facing such an allegation.
But in case of, my lord, same spirit will apply, my lord. And cruelty, regarding cruelty, whether it is a cruelty or not, lodging such type of allegation, my lord, my lord, another judgment, my lord, that is AR 2007 Supreme Court, case 1426. From paragraph 9 onward. my lord. The expression cruelty has not been defined in the act. Cruelty can be physical or mental. Cruelty, which is a ground for dissolution of marriage, may be defined as well as willful and unjustifiable conduct of such character as to cause danger to life, limb, or health, bodily or mental, or as to give rise to a reasonable apprehension of such danger. The question of mental cruelty has to be considered in the light of the norms of marital ties of the particular society to which the parties belong, their social values, status, environment in which they live. Cruelty, as noted above, includes mental cruelty, which falls within the purview of a matrimonial wrong. Cruelty need not be physical if from the conduct of his spouse same is established, and or an inference can be legitimately drawn that the treatment of the spouse in such that it causes an apprehension in the mind of the other spouse about his or her mental welfare. Here, his or her both has been included. Then this conduct amounts to cruelty. In delicate human relationship like matrimony, one has to see the probabilities of the case. The concept, a proof beyond a shadow of doubt, is to be applied to criminal trials and not to civil matters, and certainly not to matters of such delicate personal relationships as those of husband and wife. Therefore, one has to see what are the probabilities in the case, and legal cruelty has to be found out not merely as a matter of fact, but as the effect on the mind of the complainant spouse because of the acts or omission of the other. Cruelty may be physical or corporeal or may be mental. In physical cruelty, there can be tangible and direct evidence, but in the case of mental cruelty, there may not at the same time be direct evidence. In cases where there is no direct evidence, courts are required to probe into the mental process and mental effect of incidents that are brought out in evidence. It is in this view that one has to consider the evidence in matrimonial disputes. The expression cruelty has been used in relation to human conduct or human behavior. It is the conduct in relation to or in respect of matrimonial duties and obligations. Cruelty is a course or conduct of one which is adversely affecting the other. The cruelty may be mental or physical, intentional or unintentional. If it is physical, the court will have no problem in determining it. It is a question of fact and degree. If it is mental, the problem represents difficulties. First, the inquiry must begin as to the nature of cruel treatment. Second, the impact of such treatment in the mind of the spouse, whether it caused reasonable apprehension that it would be harmful or injurious to live with the other. Ultimately, it is a matter of inference to be drawn by taking into account the nature of the conduct and its effect on the complaining spouse. However, there may be a case where the conduct complained of itself is bad enough and per se unlawful or illegal, then the impact or injurious effect on the other spouse need not be inquired into or considered. In such cases, the cruelty will be established if conduct itself is proved or admitted. To constitute cruelty, the conduct complained of should be grave and weighty so as to come to the conclusion that the petitioner's spouse cannot be reasonably expected to live with the other spouse. It must be something more serious than ordinary wear and tear of married life. The conduct, taking into consideration the circumstances and background, has to be examined to reach the conclusion whether the conduct complained of amounts to cruelty in matrimonial law. Conduct has to be considered, as noted above, in the background of several factors, such as social status of parties, their education, physical and mental conditions, customs and traditions. It is difficult to lay down the precise definition or to give exhaustive description of the circumstances which would constitute cruelty. It must be of the type as to satisfy the conscience of the court that the relationship between the parties had deteriorated to such an extent due to the conduct of the other spouse that it would be impossible for them to live together without mental agony, torture, or distress to entitle the complaining spouse to secure divorce. Physical violence is not absolutely essential to constitute cruelty, and a consistent course of conduct inflicting immeasurable mental agony and torture may well constitute cruelty within the meaning of Section 10 of the Act. Mental cruelty may consist of verbal abuse and insults by using filthy and abusive language leading to constant disturbance or mental peace of the other part. Court dealing with the petition of divorce on the ground of cruelty has to bear in mind that the problems before it are those of human beings and the psychological changes in
Okay, you need not
spouse's conduct.
elaborate. This is
My lord,
only on the
my
ground
lord,
of cruelty.
the conduct of the parties, my lord, both the parties that be considered, my lord, as per the judgment of this case, my lord. So here in this case, my lord, the appellant side has established itself regarding her conduct, regarding creating an atmosphere for not remaining, for not enabling herself to stay with the husband, my lord. And here it is there is no fault on my part, my lord, regarding her desertion. Her desertion she has created herself, my lord. And the evidences are clear here in this case, my lord, that she has left her my house, my lord, without any torture on my part, my lord. And no torture on my part has been established in this case. And desertion is complete on her own, and it has been substantiated by her own criminal cases for withdrawing the seed on, etc., my lord. So this is my humble submission before this honorable court. Issue, although cruelty has not been framed, my lord, but ample evidences are there regarding cruelty, my lord. On the basis of that, the case is decided, and accordingly, that was decided by the court below, my lord. So I support the judgment, my lord.
What about the child, daughter?
Daughter, my lord, she is living with mother, my lord. No steps has been taken.
What is your age?
My lord, 4 years at that time.
Now it's 10 years. For 10 years.
At present, what is the situation there?
You have remarried.
No. It's my humble submission, my lord. Please put it.
Yes, Mr. Sawla, anything?
You want
Material. That's it, awesome. Okay, just thought, see we could. GN Savalosene complete D Chaudhary, okay. Hearing is concluded, judgment is reserved. Okay. We'll pass judgment, we'll
Well-
reserving it.
Not.
Technique. Numbered.
But another I had.
If you want to press the review, we can press it if we can hear you. Subject to what Mr. Dutta says.
Well, if it lost, this is taking tomorrow.
Tomorrow we'll have.
Nothing. Senior councillor, some like sir.
IA4. We'll have it tomorrow. Okay. On a request made on behalf of KP Pathak Lana Senior Council, matter is adjourned to be listed tomorrow.
Well,